Welcome to this explainer. Today, we're stepping into the world of provisional patent applications, but we're going to approach this directly from our specific vantage point at IP Boutique Law. As former USPTO examiners with over 25 years of insider experience, we've seen it all. Now, filing a provisional application is so often treated as this quick, simple administrative hurdle. But from examining literally thousands of patents from the inside, we can assure you it is a highly strategic legal step. If you have an invention you're trying to protect, the quality of what you file today absolutely determines whether your priority date is actually going to hold up when it really counts.
Right out of the gate, we need to talk about a massive and, frankly, very expensive gap. It's the gap between what the USPTO procedurally accepts on day one and what an examiner will consider substantively adequate later on. You see, the USPTO accepts provisional applications without reviewing their technical merits at all. They're just checking administrative boxes. But accepted and adequate are entirely different legal standards. If your filing is merely accepted but lacks the actual legal enablement, well, your priority date might completely collapse during substantive examination.
So, here is our roadmap for today. We'll be walking through the exact procedural and substantive steps required to actually secure that priority date. We're going to cover the filing paradox, how to document your technical record, the strict enablement standard, forms and fees, managing your 12-month window, and finally, those fatal mistakes you definitely need to avoid.
Let's start with Part 1, the provisional filing paradox.
Think about the standard timeline for a moment, because it's honestly a bit of a delayed trap. You file your provisional on day one. The USPTO processes your fee, they send you a nice receipt, and you feel secure. You know you have 12 months to file your non-provisional application. But here is the catch. The critical review of your technical disclosure doesn't actually happen until the examiner review stage, which is usually 18 to 24 months later. So you're operating for 2 full years under this assumption of protection, only to find out during non-provisional examination that your original filing was too weak to support any of your claims. Having sat on the other side of the examiner's desk for decades, we can let you in on a little secret. Examiners never review provisional applications directly when they're filed. Never. What we do evaluate, years down the line, is whether the specific claims you're making in your non-provisional application find full, adequate support in that original provisional document. So the crucial takeaway here is that a procedurally accepted filing will not save a technically thin disclosure when we, or any current examiner, look closely at it later.
Moving on to Part 2, documenting the technical record.
A lot of guides treat this step like a basic checkbox, but make no mistake, this is the foundation of everything. Before you write a single word of your specification, you absolutely need a complete technical record. You have to define the minimum working configuration. You need to list out all the variations, what we in the biz call embodiments, that you might possibly want to claim later. You've got to detail specific materials, dimensions, software logic, or chemical compositions. If it's a process, outline the exact sequence of steps. Basically, you must answer these technical configuration questions with the exact same precision you would use if you were handing the project over to an engineer who had never ever seen it before.
We really emphasize this preparation because the rules are incredibly unforgiving. The USPTO strictly prohibits adding new matter to a provisional application after it's been filed. Simply put, what you leave out of your original submission stays out. If you forgot to mention a crucial alternative material or maybe a specific sequence step, you can't just casually slip it in later. Doing that exposes you to massive foundational written description rejections during your examination.
Which brings us nicely to Part 3, the Section 112 Enablement Standard. This is the single most critical statutory concept we advise our clients on, the Section 112A Enablement Standard. This is the legal requirement that your application describe the invention in sufficient detail to allow a person of ordinary skill in the relevant field to make and use it without undue experimentation. As former examiners, this is our yardstick. We evaluate your non-provisional claims directly against this strict standard. We're checking the record to see if you actually possessed the full invention at the exact time of your provisional filing. If your description requires someone to guess or play around in a lab to make it work, it completely fails the test.
And right here is where we see the biggest disconnect with inventors. A provisional specification is not your high-level summary. It's not your business plan, it is definitely not your pitch deck, and it's not a press release. We see so many applicants mistakenly file a product summary that enthusiastically explains what the invention does or why it's going to disrupt the market. But the USPTO does not care about your marketing. They need a patent quality disclosure explaining exactly how to reproduce the invention from scratch.
So to actually meet that standard, your application needs real structure. You should include a brief title, the field of the invention, the background problem it solves,
a summary, and then, most importantly, the detailed description. That detailed description section carries all the legal weight. We also strongly advise including a description of drawings. Here's a surprising fact from the inside. We frequently see applications abandoned simply because an inventor assumed drawings just weren't necessary at the provisional stage. Look, even though drawings aren't formally required for a provisional, if your invention needs a visual explanation for an engineer to understand it, omitting them severely weakens your technical record. Include the drawings. Show how the components interact. It saves you from costly rejections down the road.
All right, let's look at Part 4, Filing Forms and USPTO Fees.
The USPTO operates on a tiered fee system based on your entity size. These are the updated numbers as of January 2026. A large entity pays $325, a small entity pays $130, and a micro entity pays $65. Your filing fee depends strictly on your entity size under USPTO rules. Whatever you do, do not guess your status. Misrepresenting your entity size just to get a lower tier, even if it's completely accidental, is a serious matter that can legally impact the enforceability of your resulting patent.
The actual mechanics of the submission are pretty straightforward. Filing electronically through the USPTO Patent Center is standard practice now. You just hop in, select Utility Provisional, upload your PDF specification and those drawings we talked about, upload the required cover sheet, which is Form PTO/SB/16, pay your fee, and save your receipt. Doing this electronically gives you immediate confirmation and completely avoids any of those pesky paper filing surcharges.
When you finally hit that Submit button, you'll get an electronic filing receipt. Save it immediately, print it, back it up. This receipt contains your official application number and confirms your official priority date. This receipt is your only official record from the USPTO. Remember what we said earlier? They are not reviewing your filing right now. They will not contact you, they won't examine the application, and they will not issue any office actions during the provisional period. Their silence does not mean your application is brilliant, it just means the check cleared and it was received.
Let's move to Part 5, Managing the 12-month window.
You have exactly 12 months from the filing date. Not the day you got a confirmation letter in the mail, not the next business day, 12 months from that electronic filing date. This is your golden window to refine the invention, assess its commercial viability, talk to investors using the magic words, patent pending, and prepare to file the full non-provisional application before it automatically abandons. And just to be crystal clear, this deadline cannot be extended under any circumstances.
As you approach that 12-month mark, you've got a critical strategic choice to make. You can either file a new non-provisional application claiming priority to the provisional, or you can convert the provisional directly into a non-provisional. We generally advise our clients that filing a new non-provisional is strategically superior. Why? Because converting a provisional means your 20-year patent clock starts ticking from that earlier date, literally costing you up to a year of your total patent life. By filing a new non-provisional, you preserve the full 20-year term from the later date while still enjoying the protective priority date of the original provisional. It's a win-win.
Finally, Part 6, the fatal priority date mistakes. Over our decades of experience, we constantly see the exact same common missteps repeated, and they just ruin otherwise great patents. These include inadequate technical disclosure, leaving an inventor off the paperwork, publicly disclosing the invention before filing and completely blowing your international novelty rights, confusing the processing date with the actual filing date, and assuming the filing is adequate without having a technical attorney review it. These are the precise moments where inventors permanently lose their early priority dates, leaving them totally legally vulnerable to prior art. Let's highlight a couple of these because they're huge. Missing an inventor? That is not just a paperwork typo. It is a fundamental matter of record that deeply affects patent validity. We hear it all the time. Oh, well, they signed over their rights to the company, so I don't need to list them. Wrong. That is entirely incorrect. Every single person who contributed to the conception of the claimed invention must be formally named, without exception. Ownership and inventorship are two completely different beasts under patent law. But without a doubt, inadequate technical disclosure remains the absolute most costly error. As we stressed throughout this explainer, the USPTO will happily accept it procedurally today, but examiners will relentlessly reject it substantively tomorrow. Trying to fix a non-enabled, legally thin provisional disclosure is substantially more expensive, and honestly sometimes totally impossible, 24 months down the line compared to just drafting it properly on day one. We really hope this explainer helps you approach your provisional filing strategically, treating it with the true technical rigor it demands. We want to leave you with a crucial question, and we want you to really think about it. If an examiner at the USPTO picked up and reviewed your provisional application right now, would your foundational technical disclosure actually survive the strict Section 112 enablement standard? Make absolutely sure it's built to protect your invention when it actually counts. Thanks for joining us for this deep dive.